Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is John Roberti, and today's topic is, what is the relationship between privacy and competition? A conversation with Commissioner Noah Phillips. You hear a lot of discussion about privacy and antitrust, and not just in the antitrust world. It's gone mainstream. A lot of commentators will talk about privacy as a dimension of competition. So when you give your data to a company to use a service, is that really the same thing as paying money? What's the role that privacy plays in evaluating market power? Lots and lots of issues, and these are really new issues and new things that we have to really think about as we evaluate competitive issues. Well, in today's show, we're going to talk to one of the leading government regulators on this issue who has thought quite a lot about it, and I think you'll be very interested in what he has to say. My co-host today is Sergei Zaslavsky. Hi, Sergei.
Hi, John. How are you?
Sergei, what are we talking about today?
So we're going to be talking about the relationship between privacy and competition. We're going to discuss to what extent these doctrines are related, whether there are tensions between the two, and whether the two are on a path of convergence, or if we should be careful to keep them separate.
Why is this important?
Well, privacy has been an important topic for a long time, but it's certainly been in particularly sharp focus the past few years. As data-centric business models are becoming more prevalent, where companies collect data about their customers and either find ways to monetize that data or use that data to improve their offerings, data privacy has become a much more prominent subject. And with many of the data-centric businesses also being the subject of antitrust discussion, there naturally has been a lot of conversation about whether these two domains relate to each other, what the relationship between the two is. Are they in tension? Are they in a path to converge, or perhaps even both? And these are not just academic questions. They affect a lot of day-to-day activity and some of our economy's most successful companies.
Well, who's our guest today?
Well, we are very excited to welcome Commissioner Noah Phillips to the show. Noah Phillips has been a commissioner at the Federal Trade Commission since May 2018. Prior to that, he served as chief counsel to Senator John Cornyn. He has spoken multiple times on the relationship between privacy and competition, and he's very knowledgeable and passionate about this subject. We're very lucky to have him join us today.
Yeah, Sergei, as with all of our guests from the government, of course, Commissioner Phillips speaks only for himself and not for any other commissioner or for the commissioner or any commission employees. But let's bring him in. Commissioner Phillips, welcome to the program.
Thanks for having me. It's great to be here, John.
Great. So people often talk about convergence of privacy and antitrust. But there are some important tensions between these two domains as well. Could you talk about what you see as some of the major tensions between privacy and antitrust?
Sure. So I think it's important to start with some table setting. You've addressed a little bit, and John has addressed a little bit why we're talking about this issue. If you go back over the course of the last decade and a half, and you read some of the statements coming out of U.S. regulators, in particular the Federal Trade Commission, folks like Commissioner Pamela Jones-Harbor, you'll see arguments for beginning to bring the two doctrines together. And if you look at the last few years, certainly the last few months, even the last few weeks in Europe, you see a growingly loud drumbeat to try to merge the two doctrines. This is probably it probably reaches its apogee in the decision of the German High Court in the Facebook case. But it's something you see people across Europe talking about: privacy regulators, antitrust regulators, and of course, commentators. My view is that there are tensions between the two. And I think that as we have a conversation about convergence or merger, failing to recognize those tensions is really not being adequately honest and not recognizing the problematics that might attend if you tried on some broad basis to merge the two doctrines. At the end of the day, data privacy very much is about restricting access to a kind of information, data that concern people. And that's all well and good. It may be all well and good. And there are a lot of debates about privacy policy standing on its own. But at the end of the day, it's about restricting something. And that can be in tension with interests we may have in the context of antitrust. So one thing that we think about when we're looking at conduct or mergers that occur in a space where consumer data is at issue, and privacy in the main is about consumer data, right? It's not data about widgets, the speed of production in a plant or what have you. There are all sorts of data, of course. But when you're dealing in one of these contexts, you may want to also be thinking about how limitations on data, on sharing data, inhibit the competitive process, right? If you think that having a lot of consumer data is a barrier to entry, if you think that having a lot of consumer data gives one firm a leg up against its competitors, or that firm's restricting access raises a competitive issue, there's some tension you've just created with privacy. In a speech that I gave a while back, I cited two instances that had come before us as a commission where this seemed sort of to arise. Both were consumer data privacy cases. One case involved a company called Unroll.me, the business model of which was to look at the contents of Gmail and supply it to Rakuten, which does market research. And they would search your Gmail for records of purchases like receipts. Although it wasn't at issue in the case, over time, Google decided to restrict access of third parties to the contents of Gmail. Now, that's unquestionably, in my mind, a good move for privacy, right? However you feel about geolocation data or cookies that track your browsing online, the contents of your emails are pretty core to how everyone defines the privacy interest, whether it's vis-a-vis the state or vis-a-vis companies. And so limiting access to that makes all the privacy sense in the world. But I think it is also safe to say that those data had value and that Google's exclusive access to those data, as opposed to putative competitors of Google, raises something of a competition concern. Now, I'm not saying there's liability here, but at the end of the day, the two vectors are moving in different directions. The other thing that I brought up in the speech involved our Facebook settlement, largely for Facebook's violations of the consent decree that it had entered into with the FTC. There was one critic of that consent decree, Alex Stamos, who's a very bright guy on data security and data privacy issues. He used to be in-house at Facebook. He's now at Stanford. And Stamos quipped on Twitter that maybe we were moving in the wrong direction, because what the Facebook case concerned more than anything else, it was about a number of issues, but more than anything else was the access that Facebook allowed through its Graph API to third-party app developers to the data that Facebook collected about people and their friends. Again, those data are valuable. And cutting off access to those data isn't necessarily something that's going to promote competition, but it did promote privacy. And my point isn't that either of these cases or Google's decision to cut off third-party access to the contents of Gmail are good or bad. My point is that when you talk very broadly about merging these two doctrines, you must recognize that there are cases where they are in tension. And by the way, we don't just see this in the context of cases that the FTC has brought. I'll pick on Google again, and maybe fairly or not. Google also announced that it would be limiting the ability of third parties to use cookies on Chrome, right? Allowing those third parties to gather a lot of information to which Google is privy about what users are doing online. Good for privacy? Probably. Good for competition? Probably not. So there are all these sorts of tensions that exist. And I think we need to grapple with that.
That certainly makes a lot of sense. And, as you describe it, it's certainly easy to see a lot of situations where a company may be facing a decision. They do something that may be good for privacy, but arguably not as good for competition, and vice versa. And given the current still developing state of the law, it must be difficult for companies to chart the right path in some of these situations. And maybe we'll come back to that a little bit later. But right now, I want to explore whether, despite these tensions, there are areas where privacy can be a dimension of competition and should be considered as part of your ordinary antitrust analysis. Are there instances like that where you see privacy be playing a role in your traditional antitrust analysis?
So the short answer to that question is yes. While I think there is a great deal of debate over the meaning of privacy, and I think for purposes of this discussion, we should probably table that debate. At the end of the day, privacy is a kind of value. And in that, it's an aspect of quality. And certainly, you could conceive of a set of facts where companies were competing on that, and the lessening of competition would impact that. So one example would be, if you think about DuckDuckGo, the browser that advertises itself as a pro-privacy alternative, in particular to Google. I was driving a few weeks ago around Richmond, and there were all these DuckDuckGo billboards advertising privacy. So this is a firm that is competing on privacy very clearly. Were Google to buy DuckDuckGo, I think we would want to kick the tires, right, on whether that could result in some lessening of competition. I think that is certainly a theoretical possibility. But I do think there is a lot of difficulty and failure to recognize in some of the people who are really talking about merging the doctrines, the complexities involved in this kind of analysis. So let me just name one or two things. The first would be that privacy is not like price. Everybody wants lower prices. People have very different appetites for privacy. They may have different levels of elasticity for a given product or service when it comes to price, but at the end of the day, you'd rather part with $1 than with $5. Privacy isn't quite like that. People experience business behaviors that implicate privacy in what can be absolutely different ways. So take the example of the person who walks by a Starbucks, and because of the geolocation or even the Bluetooth information that they're cell phone is transmitting, some sort of vendor enables Starbucks to push an ad to them for a half price latte or whatever. There are people out there who view that as profoundly creepy. They really don't like the experience of these firms. Maybe they're not even really privy to them, knowing where they are, knowing what their tastes are, and then using it to make money, right? And selling them advertising. But there's another person who walks by and thinks that's fantastic. I didn't even realize I wanted a latte, and here a half-price latte is appearing in my phone. I'm going to go get it. So people, firms, all sorts of actors in the economy have different tastes for lots of different products. But on privacy, it's a lot more muddled. And I think that's a problem. Another problem I think we need to grapple with is what you don't want is people like me, law enforcers, or people like judges substituting their taste for privacy for good analysis of what is actually going on in the market. There's a lot of rhetoric about privacy, but people don't, again, always agree. And you don't want to end up in a situation where what's substituting for your analytically driven understanding of value, of quality, is in fact just taste. I think that's a very dangerous place to go.
That makes sense. And you described some of the differences between privacy competition and price competition, and they certainly are very different. One way in which we could imagine them being different is if we have a merger between two companies in the same market, we can more or less presume they're probably competing on price. Would it be fair or unfair to make a similar presumption about privacy if we have two companies, both of which collect user data and they're in the same market? Does that necessarily mean they compete on privacy and privacy is going to play a prominent role in a review of that merger? Or is that a more difficult determination to make than it would be with respect to price competition?
I think it's a more difficult determination. Companies may compete on privacy. I gave the example a moment ago of DuckDuckGo. That company is clearly competing on privacy. But in particular, when you think about, well, even not even specific to large firms, but firms compete across, in a variety of ways. If you think about data-driven firms, they may compete on the quality of user interface or the apps that they support. There are lots of different ways. One thing we'd want to know at the outset, right, is are they actually competing on privacy? I think without that competition going on, even if one person or many people even could view one company as being quote unquote better on privacy and the other company worse, one thing we'd want to know is that how the competition is happening? Is that an aspect of the competition between these firms? Because if it isn't, it's hard to see how the merger, may substantially lessen competition, which is ultimately, at least under the Clayton Act, the question that we're asking.
So let's deal with a different merger hypothetical. Let's say there are two companies, both use data. One of them uses data for some narrow purpose. Another one uses customer data for some broader purpose. And the company that uses data for a broader purpose acquires the company that used data for a narrower purpose. Now, some observers would be concerned that the customers of the acquired company shared their data with the understanding would be used for one purpose, and after the acquisition, all of a sudden their data would be used for some different, broader purpose. In your view, is that a concern that should be playing a role in merger review? And if so, how do you think about this?
What I would say is that the lessening of privacy, let's assume we can agree on a definition and that a thing is lessening it, but the lessening of privacy unto itself doesn't necessarily present a competition problem. What we want to look at is there competition that on privacy that will be lessened? So simply to say consumers at the end of the day will have less privacy because the acquirer has a looser policy on whatever, sales to third-party data brokers or something like that. I don't think that is necessarily a lessening of competition in privacy. So it may upset consumer expectations, but upsetting consumer expectations isn't in and of itself evidence of a lessening of competition. And competition is the question that, antitrust law requires us to look at. So I don't think that in and of itself a lessening of privacy. It is possible, again, if there is competition on privacy, that privacy as an aspect of quality is some sort of non-price harm at which we would look. But standing alone, a lessening of privacy doesn't necessarily indicate a competitive problem. And that brings me to another point that I think is really important to understand. My view is that there are a lot of, frankly, Pollyannish notions being pushed right now about what competition would produce if it looked better with respect to privacy. What do I mean? We know that good competition can help drive a lot of good things, including lower prices, including higher quality, including innovation, variety, so on. But it isn't always clear to me that competition is the problem in privacy, at least the way a lot of people define privacy. Because one of the things that we see when you look at the literature about privacy is that the preferences that some people articulate, and even the preferences that many people will articulate if you ask them, would you prefer more privacy or less? Would you prefer your data to be shared or not? Is that the revealed preferences are not necessarily the same. Again, when it's a lower price, I suspect that opinion and revealed preferences align much more than they do on questions of privacy. And where that is so, I think it is not entirely correct to just surmise that if we had this, that, or the other kind of competition, the result would be more privacy. So one example that I give in my speech, there's a lot of talk about breaking up big tech companies, some of which have problematic privacy practices. If you were to break them up, it is not self-evident that privacy would be the basis of the competition. It might be, but it might not. And it may be that what the firms would compete on is to generate revenue from using that data or even selling that data. It's not self-evident that privacy is the result. To my mind, right, the reason we have privacy law, in particular consumer data privacy law, is because we presume there is some sort of market failure, right? That's traditionally the justification for regulation. And if you think there is a market failure, competition may not be the salve that you need.
Commissioner Phillips, there's been a lot of discussion about the potential for federal privacy legislation. What role do you think competition concerns should play in future privacy legislation, particularly given some of the issues you discussed earlier, how the two may be in tension, and a company may face a situation where it isn't sure if a particular course of action may be good for competition, but may get it in trouble on antitrust or vice versa. Do you think the federal legislation could help clarify this a little bit for our companies and create some clearer standards around some of the tensions between privacy and competition?
I'm less concerned about a company finding itself between the Scylla of antitrust liability and the Carbitis of privacy liability. That's not the core of my concern. I think there's probably, it depends on the case, but a fair amount of wiggle room. My bigger concern And what I've said publicly is I want Congress to think about the competitive impact that privacy legislation may have. So one of the things that regulations tend to do is raise compliance costs. They tend to create barriers to entry. They tend to entrench incumbents. And I think that more than anything, what Congress and states need to keep in mind as they move forward and they think about what is a good privacy law, what maybe isn't the best privacy law, is avoiding as best they can those effects. I look at the example of GDPR, the example of CCPA, although the implementation of that law is very new. And I don't know that we see a world of increased competition. There are some indications that suggest that aspects of competition are declining. And that may be the right trade-off, to be clear, because these are different values. The whole point about them being in tension is you have to weigh these things. But I do think as we head into what kind of law do we want, people should have in mind the competitive impact that a law may have.
And you mentioned the GDPR and CCPA, and certainly different jurisdictions may come to different conclusions about the proper trade-offs. And to what extent is that an issue, given that a lot of the companies being regulated are global companies, and there are a lot of problems with having a potential patchworks of different regulations? Do you think that there is going to be a move to some sort of convergence on privacy standards and the proper trade-offs between privacy and competition across different jurisdictions?
I hope so. I fear not. I fear the vector lately has been away from that. Lots of different jurisdictions are trying lots of different things. And that's especially hard for smaller firms because dealing with a multiplicity of regulatory regimes is something you can do if you have a lot of lawyers. But I would rather have a lot of engineers. The other thing I'd add, which is really important, is that having coherent laws, having laws that are either the same, I support having one. If we're going to have privacy law in the United States, it's better to have one than to have 50 different ones, isn't just good for companies. It's good for consumers. Because the more clear, the more widespread a standard, the more clear it is. Having to think about your privacy differently when you cross the border from one state to another, or even when you arrive in another country, is harder for consumers to understand. The more simple things are, but also the more similar they are, the more clear they are to consumers. And my view is that a lot of what's going on with privacy now, people kind of recognizing some of the issues that we face and not being happy about it, a lot of that is about consumer understanding. And things that we can do, in my mind, to foster good consumer understanding are going to help a lot in terms of privacy.
So you said that you hope we will have a convergence, but you have some fears or some doubts that it will be realistic to do so. What aspects of privacy approaches in other jurisdictions do you think are obstacles toward forming a consensus that really makes sense?
I mean, look, I think there are a lot of obstacles. One thing that jumps to mind, just because it happened last week, is the European Union Court of Justice invalidated the Privacy Shield Agreement, which is an umbrella agreement that provides a legal basis for the transfer of data about European citizens to the U.S. I'm not an expert on European law, but the court deems the U.S.'s national security practices not to be adequately protective of privacy. My view is that our national security practices and the privacy protections that we have vis-a-vis the state, the Fourth Amendment, the Stored Communications Act, ECPA, whatever, goes on and on and on, are as or more protective of privacy than similar laws of European member states. But looking at our laws, failing to take into account their laws, and arriving at a conclusion that we don't protect privacy as well, I think brings people further apart or pushes people further apart. And that's disappointing to me.
Commissioner Phillips, it's so wonderful to have you on today. Recognizing that you only speak for yourself, of course, in this program, it's just great to have your views and have them out there. And I think people get a lot out of it. One quick follow-up question: you mentioned during the discussion today a speech. What is that? Remind us what that speech is. And I assume it's available on the website.
So I'm blanking for the particular name I gave it. It's something like, should we let this merger happen? It was a speech that I gave in January at Stanford Law School, and it is available on my website.
Great. And we'll get that linked up on our website as well, so folks can read about that as well.
Terrific.
But maybe we'll shift gears a little bit here and ask you what may be the hardest question of the entire program. Tell us something interesting about yourself that we wouldn't know if we only knew you professionally.
So I'm going to go bigger, John. I'm going to link myself and Sergei. The interesting thing that you should know, and this did not affect any of the questioning or any of the answers in this podcast, is that Sergei and my wife were on the same floor their freshman year of college.
Interesting. Sergei, I'm going to have a series of questions. I'm going to have a series of questions for you about that. But now, how is it that two brilliant people end up on the same floor like this? Where were they? What was going on?
We went to Antitrust camp. No, we both went to Dartmouth College undergrad. Sergei and my wife were the same year.
I see. And what does your wife remember about Sergei?
I'm going to veto that question.
I can tell you, John, but I'd have to kill you.
Well, we wouldn't want that. Commissioner Phillips, let's shift gear again and maybe a little bit more seriously. Do you have advice for younger lawyers that would like to pursue a career in government service as you've done? You've done it in, I think, a couple of different ways. What advice would you have?
So my best advice is the advice I wish I had given myself. Many of the very talented lawyers who end up in public service and government service come from educational backgrounds where their intellect and the quality of their education and the quality of their experience open a lot of doors for them. And that's great. But in the context of government, oftentimes what gets you to where you want to go is also quite a bit of hustle and selling. Certainly, I spend a lot of time on Capitol Hill, and people talk a lot about outside lobbyists, but Capitol Hill is a lot of staff and members lobbying each other, right? I want to get you as a co-sponsor on my boss's bill. Hustling can be really hard if you're introverted, if you are humble. There are a lot of reasons why it's often hard not just to ask for things that you want, but to ask people you don't even know for things that you want, people for favors who don't owe you a thing. And that isn't taught in a lot of law schools. Right? That's not taught on the bar. It's probably actually terrifically helpful if you want to build a practice, you want to go out there and pitch business. But that often is something that the partners are doing, and you don't get to that until later, if you're at a private firm. And so the thing I tell the law student or the young lawyer who wants to kind of make a jump into something very different where there's a lot of uncertainty, in addition to kind of making them aware of the risks, and usually you'll make less money and this sort of thing, is just that work on those skills. Because those are things you probably haven't been taught. In many cases, they may just not come naturally to you. And that's fine. That doesn't make you a worse person at all. It just makes you not the kind of person who is as comfortable walking up and asking, perhaps in an uncomfortable way, someone to do something for you. But it's really often important. And you get told no a lot. So it's risky. But that I think is, if there's any lesson, when I talk to law students at law schools, that's what I try to leave people with.
It's interesting. I take away two broad points from what you said that really resonate with me. One is one thing you've already said, which is the idea that you have to go and do uncomfortable things. I mean, nothing unethical or nothing, nothing bad, but just things that you wouldn't, that socially or maybe are not what you'd want to do, like asking people for things or correcting people when you think they're wrong, or being forceful in your own views. That's really hard for young lawyers, but it's a skill that I think is really important almost no matter what you do. And hustle, what you've described as hustle is I think a big part of that.
Yeah, I remember it took me 2 years to get to Capitol Hill from a law firm. And I remember learning to end what were called informational interviews, which is you were not getting a job with this person, by asking them for names of other people and would they forward your resume and this kind of thing. It took a lot for me to build to that level of comfort.
100%. And then the other thing that resonated with me, you said a moment ago, is my children sometimes ask me what I do, and it's a really good question. I struggle to tell them, but as a lawyer, as an advocate, what I tell them is my job is to convince people to do the thing that I want them to do, and that requires me to use all different tools of persuasion. Sometimes it's writing a brief, sometimes it's standing in front of a judge. A lot of the time, it's just talking to people, either coming to compromise or bringing them to where you think they need to be. It's also all different dimensions, because sometimes it's convincing the client that what you want them to do, that what you think they should do is the right thing to do, or convincing your adversary or convincing an ally on the same side of a case as you. So the skills that you've described about persuasion using different tools, I think also resonated with me.
Without a doubt.
All right, well, let's go to our final segment that we call The Curious Hat.
And now it's time for The Curious Hat.
In times when we were all together in the studio, we had an actual hat that had actual questions in it. And the guest would pull out the actual question and we would ask them the question, the guest would answer. In these times, we are not all together, so I am wearing a hat. And rather than the questions being in the hat, they're on a piece of paper in my hand. They're numbered 1 to 25. Commissioner Phillips, could you please choose a number between 1 and 25? And I will ask you that question.
I choose 9.
Question number 9. I like this one. If you had to describe yourself in 3 words, what would they be?
And I can't choose a different question? What would they be? Extrovert. Dad jokes. Let's call that one word.
Hyphenated.
Jewish.
Interesting. And I'll ask the follow-up question. If you had to describe a perfect podcast in 3 words, what would they be?
It's so funny. It would be our curious amalgam.
And ladies and gentlemen, with that...
Correct answer.
And Commissioner Phillips, thank you again for coming and joining us. We really appreciate it. It's so valuable for our listeners. And we will see you next time on Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.